Hello everyone. Let us start with a topic called accident. This particular topic has been defined under Section 80 of the Indian Penal Code. As per the marginal note of Section 80 of the Indian Penal Code, that accident in doing a lawful act. So uh, you must see very carefully that what is written under the marginal note, that accident in doing a lawful act. What does it mean? The person was doing a lawful act, and in doing of lawful act, something happened, an accident happened. What does it mean? That means the act was not an unlawful act, the act was not an illegal act, and it was not by illegal means. So the person was doing a lawful act, and in that lawful act, an accident happened. For example, a doctor is operating over the patient. That is a lawful act. And while operating over the patient, some accident happened. Or someone driving over the road. So driving over the road, it is a lawful act. And during that lawful act, uh, the car collide with some other car. What does it mean? Something else happened, and that accident happened, and therefore it cannot be an offense. The person would claim a benefit, the person would claim a defense under Section 80 of the Indian Penal Code. So as per Section 80 of the Indian Penal Code, that nothing is an offense. So it start with the marginal note that nothing is an offense which is done by accident or misfortune. You must see there are two terms, accident and the misfortune, and without criminal intention and the knowledge. So it was done either in accident or misfortune and without criminal intention or knowledge. What does it mean? There was no guilty mind, there was no mens rea, or there was no knowledge either. There was no knowledge that he is going to commit an accident or he is going to commit an unlawful act. In doing so, the qualification is in doing the lawful act in lawful manner by lawful means with proper care and caution. So these are the three, four ingredients that it was done in either in accident or misfortune. There was no criminal intention. There was no knowledge that something would happen, and it was done in doing of a lawful act. Since it was done in doing of lawful act, so definitely there cannot be an offense. It was done in the lawful manner. What does it mean? The person was driving car with minimum requirement of the speed, or he was driving a car with the proper license, and it was done in the lawful it was done by lawful means with proper care and caution. So it was done in good faith, there was proper care and caution. So what we understood is that there are ingredients. Number one, it was a consequence of an accident or misfortune. Point number two, the act was done without criminal intention or knowledge. The act done was a lawful act by lawful means in lawful manner with proper care and caution. So the principle is statutory recognition to the common law doctrine, that is the doctrine of mens rea, that there can be no crime without guilty mind. As you know, actus non facitorium nisi mens rea. What does it mean? Actus reus and mens rea both must coexist. As I already told you, actus reus plus mens rea both must coexist. Without mens rea, there cannot be a crime. Actus reus per se is not an offense, although there are certain exemption, there are certain exceptions to it. For example, structural offenses, environmental offenses, strict liability offenses, absolute liability offenses. There are certain offenses where actus reus per se is an offense, but in general, actus reus plus mens rea is equal to an offense. Without mens rea, there cannot be an offense. Now, come to a very important aspect of the term accident. This particular term has been derived from the term accidere. Uh, ACCEDERE. That means to happen. बस कुछ हो जाता है. And the core of the principle is that there was no fault of either party. किसी भी पार्टी का कोई भी फॉल्ट नहीं होता है, but something happened. So any consequence which could not be contemplated, ऐसा consequence जिसको contemplate नहीं किया जा सका. Any consequence which could not be imagined, any consequence which could not be designed, or any consequence which could not be expected. What does it mean? It was undesigned, it was unexpected, and thereby something happened. No man of ordinary prudence could anticipate under such circumstances that this was contemplated, this was imagined, this was designed, and this was expected. That no man of ordinary prudence could anticipate that these things would happen. Here, under the law, under section 80, the accident and the misfortune both are used interchangeably, and both are having more or less similar meaning, and both implies injury to other. Either accident or the misfortune both implies injury to the other, and in particular there is no distinction maintained between the accident and the misfortune. But for the sake of our understanding, we must understand that what is the distinction between the accident and the misfortune. As you know, in case of accident there is no element of mens rea, and in case of misfortune also there is no element of mens rea, and that something happened, and on the cost of no fault of others. There was no fault of other, but still it happened. So in case of misfortune, it is a bad luck. It is a bad luck of one party or the other. But come to the distinction between the accident and the misfortune. In case of accident, one party get injuries. You must keep in mind that in case of accident, one party get injuries, whereas in case of misfortune, both the parties are getting injuries. You must underline this particular phrase, that in case of accident one party get injuries, whereas in case of misfortune both the parties are getting injuries. Now let us come to the illustration. You may go through the illustration number 1 of the section 80 of the Indian Penal Code, but for the sake of our understanding, suppose there is a workman, एक कोई मजदूर है, एक कोई वर्कमैन है, वो किसी अंडर कंस्ट्रक्शन बिल्डिंग में काम कर रहा है, थर्ड फ्लोर पे, फोर्थ फ्लोर पे, और इवन फिफ्थ फ्लोर पे वो जो है काम कर रहा है. होता क्या है कि नाउ ही स्टार्टेड थ्रोइंग द ब्रिक्स और द स्टोन फ्रॉम द रूफटॉप आफ्टर गिविंग द प्रॉपर वार्निंग. उसने जो है प्रॉपर इंफॉर्मेशन दी कि भाई जो भी नीचे है वो हट जाए, थोड़ा थोड़ा दूर हो जाए, मैं ऊपर से ब्रिक्स या स्टोन फेंक रहा हूं. बट द अनदर वर्कमैन who killed by the stone or the bricks, that is the pure case of accident for which A shall not be held responsible, and thereby A can claim a defense under section 80 of the Indian Penal Code, because there was a lawful act, it was done in the lawful manner, it was done in lawful means, there was no intention, there was no knowledge that this thing will happen, that B would be killed, and therefore it is a pure case of accident, and here only one party get injuries. Here only one party get injuries. अब कोई दूसरा एग्जांपल लेते हैं. सपोज करिए कि दो चार लोग सैर सपाटे के लिए जंगल में निकले, शिकार करने लगे, उनके पास एक रिवॉल्वर होती है या कोई बंदूक समझ लीजिए, वो उसको उससे जो है किसी जानवर को शूट करना चाहते हैं. होता क्या है कि while shooting, suppose A, B and C, three person are there, and A wanted to shoot an animal. एनिमल को शूट करते टाइम होता क्या है कि बुलेट किसी ट्री से या किसी स्टोन से टकरा करके रिटर्न आती है, वापस ऐसे बुलेट जाती है और फिर रिटर्न आती है, रिटर्न आकर के बी को लग जाता है, सेम बुलेट जो है बी को लग जाता है, एंड देयर बाय बी किल्ड. दिस इज आल्सो अ केस ऑफ accident. It is a case of accident where one party get injuries. Come to the point on misfortune. अब misfortune पे आते हैं. misfortune के केस में क्या होता है? In that case, both the doer, or you can say the wrongdoer, and the other party, both are getting injuries. Both are getting injuries. For example, एक एग्जाम्पल ले लेते हैं. सपोज करें कि 2 कार are running at the speed of 80 km per hour from the opposite direction. They are running in the opposite direction and thereby they collide with each other. वो जो है एक दूसरे से कोलाइड हो जाते हैं. और एक जो है क्रॉसिंग है, एक कार इधर से आती है, दूसरी कार इधर से आती है, दोनों एक दूसरे को देख नहीं पाते और कोलूजन हो जाता है. So in such a situation that it resulted into an injury to both the drivers, both the cars or both the properties, and therefore it is a pure case of misfortune. So you must keep in mind, in case of accident one party get injuries, and in case of misfortune both the parties are getting injuries. So it was unintended, there was no intention, there was no knowledge, it was unplanned, there was no planning that we must collide with each other, there was no design. What does it mean? It was undesigned, it was unexpected, and therefore it was not foreseen. It could not be foreseen that something would happen like that. And in case of designing, in case of every designing, there is an element of thought. कुछ जो है थॉट प्रोसेस होता है, दो चार लोग बैठ करके डिसाइड करते हैं या सिंगल पर्सन बैठ के डिसाइड करता है कि व्हाट वुड हैपन नेक्स्ट. एंड देयरफॉर इन केस ऑफ मेंसरिया देयर इज एन एलिमेंट ऑफ थॉट. कुछ जो है थॉट प्रोसेस होता है, उसके बाद जो है एक फाइनल रिजल्ट इंस्यूड होता है. बट इन केस ऑफ एक्सीडेंट, इन केस ऑफ मिसफॉर्चून, देयर वाज नो डिजाइन, देयर वाज नो प्लान एंड देयर वाज नो एक्सपेक्टेशन एंड इट वाज नॉट इंटेंडेड. नाउ कम टू अनदर एग्जाम्पल. एक और एग्जाम्पल लेते हैं जो थोड़ा सा आपको परेशान कर सकता है. सपोज करिए कि ए एक इंसान होता है, बी दूसरा इंसान होता है और सी तीसरा इंसान होता है. होता क्या है कि ए वांटेड टू किल बी. ए जो है बी को मारना चाहता है and therefore he mixed poison into the bee's food. बी के फूड में वो जो है पॉइजन मिला देता है. बट अनफॉर्चुनेटली सी एस कजन, ए का जो कजन सी होता क्या है कि ही टेक्स फूड, वो जो है फूड को ले लेता है और नाउ ही ate the food and thereby he died. पॉइजन मिक्स किया हुआ फूड सी खा लेता है और उसकी डेथ हो जाती है. नाउ हियर सीज डेथ इज एन एक्सीडेंट. सी की जो डेथ है दैट इज एन एक्सीडेंट. बट एक whether he can be held responsible or not, whether he can be exempted from the criminal liability or not, because it was an accident. By accident C killed, but he intended to kill B. Since it was an illegal act, it was not a lawful act, it was not in lawful manner and not by lawful means, and thereby he cannot be exempted from the criminal liability at all, and therefore he cannot claim an exemption under section 80 of the Indian Penal Code. So you must keep in mind that the person cannot claim an exemption under section 80 of the Indian Penal Code. Come to the point of lawful act, lawful means, and the lawful manner. As it is a mandatory requirement that there should be a lawful act, it was done in lawful means and in lawful manner. Let us take the example that A, the person who went into the jungle and while shooting a jackal in the jungle with an unlicensed gun. I underline the term unlicensed gun. And by accident he killed another man who was behind the bush. The another man who was behind the bush, and therefore he killed the man by unlicensed gun. He would not be liable for the murder. Now you may ask the question, why he should not be liable for the offense of murder or culpable homicide? The fact that A was having an unlicensed gun not preclude him from claiming a defense under section 80 of the Indian Penal Code. Why? The reason is circumstances in which cannot be held liable for the offense of murder and he can be exempted from the criminal liability. Come to the point that causal connection between the resultant harm and the action. What is the relation between the harm, the resultant harm, and the action? We have a case called Jageshwar versus Emperor. It was decided in the year 1924 by the Awadh High Court. In this case, what happened? The accused was beating a person with his fist. With his fist, he was beating the other person, and when another's wife interfered in between. When two persons were fighting with each other, then one's wife, she interfered in between, and what happened? With She interfered with a 2-month child in her arm. There was a child in her arm, and what happened? A blow hits the child. एक ब्लो जो है चाइल्ड पे पड़ जाता है, एंड देयर बाय द चाइल्ड डाइड. बच्चे की डेथ हो जाती है. Although the child was hit by an accident, but the accused was doing an unlawful act. The accused was doing an unlawful act. It was done in unlawful manner and by unlawful means, and thereby it is an offense, and the accused cannot claim a benefit under Section 80 of the Indian Penal Code. We have another example, another two illustration in the draft IPC. In the draft IPC, if you go through the draft IPC, then you would see under Section 82 illustrations. That is, there was a pilot. He was navigating in the Hooghly River with the utmost care and skill, and he diverted the vessel against the sand bank. It was not known to him, and consequently, he lost 100%. Since the ship collided with the sand. So the passenger died, and it is said in the illustration itself that to hang the pilot would be injustice, because there was no element of mens rea, and therefore it was a pure case of accident, and therefore the person should not be held responsible. Similarly, we have another case called State of MP versus the Rangaswamy, AIR 1952, decided by the Nagpur High Court. In this case, there was a hyena, the Lakarbagha. You might be knowing this particular term, a wild animal. He was moving in the village and causing injuries to the villagers, and even causes death to the small child. What happened? The people complained to the authorities, and thereby the government deputed certain officers. They saw the moving animal behind the bushes. The government officer saw the hyena behind the bushes, and what happened? It was a rainy day, and therefore the visibility was very low, or you can say there was no visibility at that point of time, and they thought it was a hyena, and therefore one of the officer fired on the hyena, but it resulted into the death of the human being. It resulted into the death of human being, and the Madhya Pradesh High Court declared that accused is protected under Section 80 of the Indian Penal Code because there was no element of mens rea. Hope you have understood. You would have understood that what we call the accident, and in our next lecture, that we would study Section 81, 82, and 83 of the Indian Penal Code. Thank you. Thank you very much.